Hi, this is Brian Whipred, and I'm going to be giving you an overview of weeks 3 and 4. This is a pivotal 2 weeks. We're getting into our foundation or core topic matter in criminal law. It's the backbone of basically what we're doing for this entire semester. So I'm going to talk about few of the things that you're going to be required to do this week, and number one is to read chapter 3 in your textbook on criminal law. And just a quick overview of criminal law as it appears in the text. And we want to start off by saying laws are rules of conduct usually found enacted in the form of statutes that regulate relationships between people and also between parties. One of the primary functions of the law is to maintain public order. Laws also serve to regulate human interaction, enforce moral beliefs, define the economic environment of a society, enhance predictability, promote orderly social change, sustain individual rights, identify wrongdoers and redress wrongs, and mandate punishment and retribution. Because laws are made by those in power and are influenced by those with access to power brokers, they tend to reflect and support the interests of society's most powerful members. Now, when we talk about the laws and the rules of conduct, we have written laws which are called statutes. It's statutory law. And like we mentioned earlier, the overall objective is to maintain public order and to regulate human interactions. Also, because we're a part of a Judeo-Christian society, for the most part, I don't want to say in totality anymore, because we have a number of different religions outside of Christianity, but for the most part, laws are enacted to enforce moral beliefs. Now, the rule of law, which is sometimes referred to as the supremacy of law, encompasses the principle that an orderly society must be governed by established principles and known codes that are applied uniformly and fairly to all members. It means that no one is above the law, and it mandates that even those who make or enforce law must also abide by it. The rule of law is regarded as a vital underpinning in Western democracies, for without it, disorder and chaos might prevail. In chapter 3 of your text, the chapter identifies various types of law, including criminal law, civil law, administrative law, case law, and procedural law. Chapter 3 is primarily concerned with criminal law, which is that form of the law that defines and specifies punishments for offenses of a public nature or for wrongs committed against the state or against society. We'll also talk about case law and procedural law, but criminal law will be the main focus. There's variations of criminal law, and they can be found in different types and can vary in severity. 5 categories of violations are discussed in Chapter 3. Above and foremost are felonies. Then following that are misdemeanors. Number 3 are infractions. Your book calls them offenses, but here in California we call them infractions. Treason and espionage, and then inchoate offenses. From the perspective of Western jurisprudence, all crimes can be said to share certain features. Taken together, these features make up the legal essence of the concept of crime. The essence of crime consists of 3 conjoined elements. The criminal act, which is a legal parlance, is termed the actus reus. A culpable mental state or mens rea, and a concurrence of the two. 5 additional principles added to these 3 allow us to fully appreciate contemporary understandings of crime: causation, resulting harm, legality, punishment, and necessary attendant circumstances. Written laws specify exactly what conditions are required for a person to be charged in a given instance of criminal activity. The elements of a crime are specified legal aspects of the criminal offense that the prosecution must prove in order to obtain a conviction. Guilt can be demonstrated in criminal offenders convicted only if all of the statutory elements of the particular crime can be proven in court. And finally, our legal system recognizes four broad categories of defenses to criminal charges. Number one, alibi. Two are justifications. Three are excuses. And four are procedural defenses. And an alibi situation, if shown to be valid, means that the defendant could not have committed the crime in question because he or she was not present at the time of the crime. When a defendant offers a justification as a defense, he or she admits committing the act in question but claims that it was necessary to avoid some greater evil. A defendant who offers an excuse as a defense claims that some personal condition or circumstance at the time of the act was such that he or she should not be held accountable under the criminal law. Procedural defenses make the claim that the defendant was in some significant way discriminated against in the justice process, or that the important aspect of the official procedure was not properly followed in the investigation or prosecution of the crime charged. That basically is what your chapter talks about. I'm going to go through weeks 3 and 4 with other topical material that you're going to be required to do. Like I said, you have to read chapter 3 and also review the criminal law PowerPoint presentation by the publisher. This will consolidate the readings quite a bit. Next, I want you to look at the Wikipedia, the internet site on the state of nature. And I added this because this is a foundational concept of Western civilized law. And it has its roots with three philosophers in the 18th and 19th century. You have Thomas Hobbes, John Locke, and Jean-Jacques Rousseau. And they developed and expounded upon a philosophical theory called the state of nature, in which goes back to primitive man in its formation of collective communities and establishing a rule of law based on a contract amongst the people within this collective community. This thought had significant impact on Thomas Jefferson when he wrote the Constitution of the United States, and its foundational principles for our rule of law here in the United States. So you've got this Wikipedia internet link on the state of nature that'll explain some of it, as well as a PowerPoint presentation I put together on those three theorists. I want you to review the World Justice Internet link, the rule of law, and also the Wikipedia link on the rule of law gives you kind of a historical concept. Read the internet link, the evolution of U.S. criminal law, and then I want you to review 3 different videos. First one is going to be on Kimberly Motley, who is an attorney who spent considerable time in Afghanistan in the early to mid 2000s defending Afghani citizens based on their concept of law. It's very interesting, and I thought it's very appropriate. And even though it doesn't talk about the American or criminal justice system, it does talk about the rule of law, which is uniform throughout the world. So it's a very interesting concept. I want you to watch that video. Then I want you to read the internet article, Ignorance of the Law is No Excuse. And then I need you to watch, and it's not here, I need to get it loaded, but there's another TED Talk on Philip Howard's 4 Ways to Fix a Broken Legal System. So that's those videos. And then finally I have a law student who has put together 2 short videos on the basic elements of crime. This is a nuts and bolts approach, and it'll help you understand different aspects of crime and the elements that go into them. So that concludes your overview of Chapter 3. Good luck, and we will be in contact.